and appeals in the matters of London Borough Operators and Stokes and others matters.
My Lords, may I just before Ms Bolton makes her submission, may I simply mention your Lordships and your Ladyship should have had from me on the email this morning a note about precedent as requested. There are hard copies available should any of your Lordships or anyone else need them, but I don't wish to say anything about it unless the court wants me to.
Well, we've got it. Thank you very much, Mr. Giffin, and we've read it, and we hope that the other side have had the opportunity to see it as well.
They have.
I'm sure they have.
Yes.
Good. So we're going to hear from Miss Bolton, are we?
My Lords, my Lady, good morning.
Good morning.
I intend to approach this by carrying on from where Mr. Bowes left off and deal with my issue 2, grounds of appeal first. And then with, as long as it's acceptable to the court, I would like to then finish with my issue 1 appeal, which is the Vice President ordered a rolled up hearing, where I need both your permission and for the appeal to be allowed. My Lords, yesterday, my Lord Justice Voss, you asked 3 questions. You raised 3 issues of concern, and the issues that you raised in particular were 1, can these travellers' cases be distinguished from Canada Goose? 2, how is the appellant's case consistent with Cameron? And 3, is Bromley consistent with Canada Goose? And in summary, as part of my submissions, I will provide the following answers to those questions. The answer to question 1, can these cases be distinguished from Canada Goose, is yes. The cases can be distinguished from Canada Goose because Canada Goose was a case concerned with private law principles and rights, and private law principles and rights are not usually to be applied to claims for statutory injunctions engaging public law rights, in particular planning law, in particular section 187B in this case. And that has been authoritatively cited in the past by the House of Lords, both in the case of Pioneer Aggregate and Newbury. I will turn those cases up in a moment.
Which was the case?
Pioneer Aggregates, my Lord.
Oh, right, yes.
And Newbury against the Secretary of State for the Environment. And indeed, Pioneer Aggregates was expressly referred to in the Porter case. And I'll take your Lordships to those cases shortly. So on my summary points in answer to question 2, how is the case consistent with Cameron? In relation to section 187B3, it's expressly recognised by Lord Sumption in Cameron at paragraph 9 that is a statutory exception to the general principles he is considering in Cameron. And my Lords, my Lady, that also addresses your Lordship, Lord Justice Lewison's question, paragraph 9, yesterday, concerning squatters. Because indeed, again, Lord Sumption in that paragraph recognises that that's an express exception under the CPR, where persons unknown will be bound by the order, and therefore provides no concern when it's enforced against the order. And again, I'll take your Lordships to the paragraph where those 2 exceptions are looked at. I'd also observe very briefly on that point before moving on to my summary point on question 3, that the recognition of section 187B in the Cameron case as an exception is not particularly surprising when it's noted that one of the Supreme Court justices in the case was Lord Carnworth, the author of the report that led to the introduction of section 187B3. My Lords, in answer to the 3rd question, is Bromley inconsistent with Canada Goose? The answer is no, it's distinguishable. It's clearly distinguishable because whilst there is a reference, whilst the appeal also concerned issues of trespass in relation to public law rights, it was effectively a public law case dealing with issues under section 187B and section 222 of the Local Government Act, and that's recognised in the permission. I'll again take your Lordships to the Bromley case, and the reasons why the judge gives permission to appeal. We need to remember in Bromley, an injunction was granted by the High Court. It simply wasn't as extensive as Bromley was seeking. And indeed, the intervener's original intervention on the case was to do with a planning law issue, and that of permitted development rights under the Town and Country Planning Act and the use class orders. So again, Bromley was grappling with public law issues, and again, in particular, planning law issues. And so, in my submission, it's not entirely unsurprising that it wasn't referenced in Canada Goose.
So you say, is this right, that there is a sharp division between an application brought by a local planning authority, on the one hand, and an application brought by a private landowner on the other, whether it's the Forestry Commission or the Crown Estate, or it could be all sorts of landowners who have very extensive landholdings throughout the country. And you say, do you, that Canada Goose would preclude them getting the sort of injunction that you're after?
My lords, no, I don't say that. What I say is, in the context of the appeal that I bring on behalf of the appellants I represent, the difference for the appellants I represent is that they didn't seek an order under trespass. They didn't rely on any private law rights at all. They only relied on statutory rights. And therefore, I don't have to go that far in my appeal.
On 187B,
My lord,
and your clients only relied on 187B.
no, my lord, they also relied on section 222, and in some cases they relied on section 1 of the Antisocial Behaviour, Crime and Policing
But
Act.
222 doesn't add anything. I think everybody agrees that. It doesn't create a course of action, it just gives you standing to pursue a course of action.
My lord, indeed, and my lord, that was on the basis that we were asking to come to the aid of other enforcement powers available to the local authority that were not being complied with, which was under the Criminal Justice and Public Order
All
Act.
you rely on now, as the Master's Roll says, is section 187B.
For the purpose of this appeal, my lord, yes. So, my lord, I'm not cutting across the submissions made in relation to trespass generally. I simply make the point that for the purpose of answering the questions for the appeal I am bringing, those are the answers to the question, because our claims were brought on a statutory basis under planning law, and all of the statutory basis were on alternatives, so the court could order them under and or. All of our claims involved named defendants as well as persons unknown. All of our claims included an alternative service order, and all of the final orders went through to trial. So our position is slightly different, and in relation to these appellants, they are certainly, my submission, the correct answers to those questions posed yesterday. So, my lords, first of all, turning to Porter very briefly on this issue in relation to the first question, which you'll find in the Authorities Bundle BC at page...
So where are we going?
To the Porter case, my lord, first
Porter.
of all. And that is at page... starts at page 368.
Start page.
My lord, 868. Sorry. My lords, the relevant paragraph where the reference, where we see the first reference of importance of pioneer is at page 889, paragraph 30. My lords, paragraph 30, the Lord Bingham states, as shown above in the 1990 Act, like its predecessor, allocates to control the development of land to democratically accountable bodies, local planning authorities, and the Secretary of State, issues of planning policy and judgment are within the exclusive purview, as Lord Scarman pointed out in Pioneer Aggregates and the Secretary of State for the Environment. Parliament has provided a comprehensive code of planning control, and goes on to reference Alconbury. The limited role of the court in planning field is made very clear. Now, what's meant there is, particularly in the context of Section 187B, when a claim is brought under Section 187B, the local authority doesn't have to prove effectively the underlying cause of action before the court, because that's breach of planning control and is a judgment for the local authority under the statute. But the reference there to Lord Scarman's judgment is the important reference, and if we could turn up, first of all, Pioneer, my lords, which is in bundle BC, page 541. Now, the background to the facts of the Pioneer case in essence is Pioneer purchased a limestone quarry which had the benefits of a permission for quarrying of limestone. Prior to Pioneer purchasing the quarry, the previous owners had ceased the quarrying activities and had confirmed the same. And when Pioneer occupied the site and indicated that they wished to continue with the quarrying, they were told by the local planning authority that they would require a new planning permission. Pioneer didn't accept that, and to encourage an enforcement notice to be served by the local authority, they did a test blast. Enforcement notice was served, and the matter was appealed to the Secretary of State. The Secretary of State agreed with the local planning authority, saying that the permission had been abandoned and that they couldn't rely on it and they required a fresh permission. That was appealed, and Mr. Justice Glidewell found for the owners, and the Court of Appeal dismissed the planning authority's appeal from that decision. Eventually, the matter came before the House of Lords. And in considering the issue of abandonment, Lord Scarman, at page 549, deals with the issue. And it's the penultimate paragraph you'll see that he states, "My lords, on the question of abandonment, I find myself in agreement with both courts below, but there is no such general rule in planning law." And see at the beginning of the last paragraph on that page, planning control is the creature of statute. It is an imposition in the public interest.
Sorry, I'm not quite. Is it 559 you want?
549, my lord.
549H.
Thank you.
My lord, yes.
Okay.
Planning control is the creature of statute. It is an imposition in the public interest of restrictions upon private rights of ownership of land. The public character of the law relating to planning control has been recognised by the House in Newbury District Council and Secretary of State for the Environment. It is a field of law in which the court should not introduce principles or rules derived from private law unless it be expressly authorised by Parliament or necessary in order to give effect to the purpose of the legislation. The planning law, though a comprehensive code imposed in the public interest, is of course based on the land law. Where the code is silent or ambiguous, resort to the principles of private law, especially property and contract law, may be necessary so that the courts may resolve difficulties by applications of common law or equitable principles. But such cases will be exceptional, and if the statute law covers the situation, it will be an impermissible exercise of the judicial function to go beyond the statutory provisions by applying such principles merely because they may appear to achieve a fairer solution to the problem being considered. As ever, in the field of statute law, it is the duty of the court to give effect to the intention of Parliament as evinced by the statute or statutory code, considered as a whole. So, clear judgment of Lord Scarman there is again repeating the position in Newbury that you do not apply private law principles to planning law unless it is required for the to aid the interpretation of the statute, and that such situations will be exceptional. We could also turn to Newbury, Lord Lady. It's, you'll find that at page 447. Now, this was a case where the House of Lords, and again the relevant judgment of Lord Scarman, where the House of Lords were one of the considerations was Lord Denning's application in the Court of Appeal in this case of equitable estoppel to planning law, and this was on the basis that the occupiers of the land, who were a rubber company, were using old aircraft hangars as a storage facility, and that use had effectively already been established under the use classes, and they didn't require planning permission. They didn't appreciate that at the time, and they applied for planning permission on the land which the local authority provided to them for a limited period of time. On its expiry, the local authority refused to extend it, but the occupants then asserted their use class rights, to which Lord Denning determined that they were stopped from doing so, because in his view they had elected to follow the planning permission, and having followed the planning permission they had extinguished their previous use rights. That decision was based on equitable estoppel. Lord Scarman considers the point starts at page 484, and you'll see there's the reference halfway down the page to the estoppel point, blowing hot and cold. The important part is on page 485, at paragraphs D and E.
I think blowing hot and cold is more like election than estoppel, not that it matters.
My lord, yes. And the important part is paragraphs D and E on page 485. where Lord Scarman states, as every law student who has read the opening chapters of Snell's Principles of Equity, now in its 27th edition, 1973, knows, equity as a body of law, ancillary to the common law, developed so as to provide a protection for interests in property which was more effective than the remedies available at law. The Court of Chancery acted on the conscience of the legal owner of property. Equitable interests were strictly not proprietary in character but rights in persona. Although they have developed a proprietary character, they are not enforceable against all the world. The purchase of a value without notice is not bound. In the field of property law, equity is a potent protection of private rights, operating upon the conscience of those who have notice of their existence. But this is no reason for extending it into the public law of planning control, which binds everyone. He then goes on to consider the case law that Lord Denning believed supported the application of equitable estoppel. And on page 486, it's the second paragraph. My Lords, I agree with the view so consistently expressed by Chief Justice Lord Parker that it is wrong to introduce into public administrative law concepts such as equitable estoppel, which are essentially aids to doing of justice in private law. I forbear to discuss the cases upon which Lord Denning, Master de Rolles, founded his view to the contrary, because Mr. Bodell, for the respondent, did not seek to rely upon them. Indeed, Mr. Bodell based his argument on the Prosser's case, 67 LGR 109, the principles of which is independent of any equitable doctrine. Suffice it to say of the authorities mentioned by Lord Denning in the passage which I have quoted, that if, and insofar as they suggest, and I do not think they do, estoppel has a place in the law of planning control, they are incorrect in law and should not be followed. Canada Goose is a case concerned with private law rights, and we see in the judgment of Mr. Justice Nicklin, which is in Bundle of Documents, Volume 1, at page 70,
Bundle of documents, did you say?
it's Volume 1, my lord, page 70.
Bundle of documents.
Yes, it's the first instance judgment in Canada Goose.
My lords, no, first of all, I'm taking you to the judgment of Mr. Justice Nicklin, then we'll go to the Canada Goose.
In this case?
Oh, in this case.
My
in
lords,
this
yes.
case.
Yeah, I think we're mostly using it separately. Yeah. Which paragraph of the judgment?
My lords, it's page 70 and it's paragraphs 151 to 153. You'll see that the learned judge is setting out our arguments between both mine and Mr. Bowe's arguments in relation to section 187B. And you'll see paragraph 153 says Miss Bolton, Mr. Bowes QC and Mr. Giffin QC submit that the decision of the Court of Appeal in Canada Goose to final injunction binds only the parties at the date of the judgment is either A, limited to protester cases and does not extend to traveller's injunctions obtained by local authorities in exercise of their statutory powers, or B, obter dicta and should be distinguished or not followed. And we find the decision on this point at paragraph 175 on page 77, where he says, I reject the submissions that travellers' injunctions are not subject to the fundamental rules of civil litigation, or that the principles from Canada Goose is limited only to protester cases or cases involving private litigation. Principles enunciated by the Court of Appeal in Canada Goose, drawn from the Supreme Court's decision in Cameron, are of universal application to civil litigation in this jurisdiction. Local authorities bringing litigation for the public good may be afforded certain privileges, for example, that generally they are excused from the requirement to give a cross-undertaking in damages when seeking an interim injunction, but otherwise they are subject to the same rules that apply to all litigants who pursue civil claims. My lords, it's my submission that the learned judge was simply wrong to say Canada Goose is of universal application, because Canada Goose is a case concerned with private law rights. It is not a case concerned with planning law under a statutory regime. It is clearly distinguishable from that, and we see the error the judges
Well,
made.
I mean, it may be distinguishable in that sense that, I mean, obviously you're right, it originates in public law, but what the judge here is saying is that it's a process of civil procedure which applies to whether you're vindicating a private law or a public law claim, public law right. And the justice principle, which Mr. Giffin spent most of his time referring to, the fundamental principle of justice, applies as much to defendants to public law claims as it does to defendants to private law claims. And the problem I have with all this, Ms. Bolton, if I can say so, is that we need to apply some coherence to the law. And if we salami slice these cases without any proper overview of what on earth is going on, all we're going to do is to add to the confusion that has already been created by the 15 cases that the advocate to the court has put in chronological order in his skeleton argument. And so, I mean, whilst this is a distinction, it may be a distinction without a difference.
My lord, I think to demonstrate that it's not a distinction without a difference will probably require me to move on to the second question that your lordship posed, because the distinction becomes clearer when you consider what Cameron says about Section 187B, and then it becomes clear how you approach Camel.
When you consider who said about 187B?
What Lord Sumption in Cameron said about Section 187B3, because he recognises it as an express exception to the general principles that he's considering in that case. So, in my submission, it isn't a distinction without a difference.
But even if you succeed, I mean, I remember that bit, but even if you succeed in showing that you can succeed because you brought claims under 187B and others can't because they didn't, that's pretty unhelpful.
My Lord, it's not our submission that others can't because they didn't. That's not our submission.
Well, I
at
know
all.
that's not your submission, but it may be, if you're the only one who's right, it would be the conclusion.
Well, my Lord, you'll have seen from the fifth intervener's submissions, we say it's very important that the court consider the Section 187B provision because it does have very wide implications, generally for planning control. Your Lordship asked yesterday, were these orders granted routinely? They've been granted routinely for the last 20 years. There are
Sure.
My Lord?
Sure, I know.
And they are of great importance in planning control, not just in travellers' cases, but in planning control generally, where anonymity is an issue and ownership of land is an issue which is being developed. So we say it is quite important that the court do consider this context. I don't in any way urge the court to not consider the broader context. On the contrary, I agree with all that has been said in relation to the fact that it ought to be the case that final orders can be granted against persons unknown. I simply am advocating this position because this is the position, one, we applied under, and two, there is an express provision for it of some importance.
Yeah, okay.
My Lord, again, we see the difficulty in referencing Canada Goose, though, at page 98 of the learned judge's judgment.
Sorry, I need the paragraphs.
It's paragraph 248, and it's subparagraph 7. And it's where he's summarising the procedure for a person's unknown order. He says an interim injunction will only be granted cautionary if the applicant demonstrates by evidence that there is sufficiently real and imminent risk of a tort being committed by the respondent, Canada Goose Principle 3. Planning law isn't concerned with torts. It's a completely separate category of law, freestanding from the private law principles. So on that assessment, you would never be able to demonstrate the Canada Goose criteria in a 187B case. And we say that that in itself is, again, emphasising the point that Canada Goose is dealing with a very different situation and not contemplating statutory rights. When you put, looking at the Cameron case then, dealing with the second question, which is my Lord in the bundle A of authorities, page 275. We see on page 281, paragraph 9, we see the first part. And we see Lord Sumption is saying when the civil procedure rules were introduced in 1999, the function of prescribing the manner in which proceedings should be commenced was taken over by CPR Part 7. The general rule remains that proceedings may not be brought against unnamed parties, this is implicit in the limited exceptions contemplated by the rules. And of course, he goes on later to consider how the cases have developed the general principles. He then says, later in the last sentence of paragraph H on page 281, the only express provision made for proceedings against an unnamed defendant other than representative actions is CPR 5534, which permits a claim for possession of property to be brought against trespassers whose names are unknown. My lords, that in my submission answers the question raised by my Lord Justice Lewison yesterday, in concerns to how you enforce squatters' cases on that basis, because it's an express recognition, Lord Sumption says, under the CPR. He then goes on to say in that same paragraph, and it starts partway through the paragraph, in addition, there are specific statutory exceptions to broadly the same effect, such as an exception for proceedings for an injunction to restrain any actual or apprehended breach of planning control under Section 187B of the Town and Country Planning Act 1990. Then importantly refers to Section 187B3 as inserted by Section 3 of the Planning and Compensation Act 1991, provides that rules of the court may provide for such an injunction to be issued against a person whose identity is unknown. The rules are supplemented by a practice direction which deals with the administrative steps involved. So it's very clear there, because Lord Sumption then goes on in paragraph 10 to look at English judges have allowed some exceptions, and then how the wider jurisdiction has opened up, and he's then considering the case law. So it's very clear there that he's recognising that that's a statutory exception to the general principles he is considering in Cameron. And in my submission, therefore, whatever else may or may not be the case, it's clear that Lord Sumption is not applying a more restrictive approach to Section 187B. He's expressly acknowledging the right under the statute to seek an order against persons whose identity is unknown. And my lords, that's not at all surprising when you consider the case law developments and the statute itself. And one of the cases that your lordships were taken to yesterday was the Gamble case. But of course, the Gamble case needs to be read in two parts, because there's two decisions of the Court of Appeal that are relevant to Gamble. And the first one is before Mrs. Gamble becomes party to the proceedings, and that's in Bundle A at page 1 of the authorities bundle at page 146, and that's the case of South Cambridgeshire District Council and persons unknown. And in that case, and of course that was a case which was heard by both Lord Justice Brooks and Lord Justice Clark. This is the first stage of the injunction that's relevant to Mrs. Gamble, where the local authority had applied for an injunction under Section 187B3, which included an injunction against persons unknown. And the judge in the Cambridge County Court had been concerned that they didn't have the ability to grant such an order, and so they granted permission to appeal. And first of all, you'll notice that you'll see that they're discussing in paragraph 3 the appropriate description of persons unknown. And you'll see that it's persons unknown being persons other than those listed in the schedule to the claim form, causing or permitting hardcore to be deposited, caravans, mobile homes or other forms of residential accommodation to be stationed, or existing caravans or other mobile homes to be occupied on land at Victoria View, Smithy Fen, Cottingham, Cambridge. Now that's, my lords, what I would call a traditional use of a persons unknown section 187B injunction, where you are dealing with an individual site. And of course the description is appropriate because it's reference to the evidence, but of course will bind newcomers. You then see on page 148, paragraph 7, that the court is considering the governing statutory provisions under section 187B. And then you'll see the reference to the Court of Appeal considered to be the procedural rules, which at the time were under Order 49, to now under CPR practice direction in the same form. The important paragraph of this Court of Appeal authority is paragraph 8. Lord Justice Brooks says, "I'm wholly satisfied that the statute gives the court the power to make an order of the type sought by the claimants. There was some difficulty in times gone by against obtaining relief against persons unknown, but over the years that problem has been remedied either by statute or by rule." It's quite clear in this case that the courts are granting persons unknown order under the statute, not under any limited interim relief basis, but under the statute. And we see in practice how you meet the description of persons unknown on the evidence. The evidence of what is happening is used to describe the persons unknown. That will inevitably bind newcomers, as we see in a minute, when this very injunction bites against Mrs. Gamble. So, my lords, we then need to turn to the Gamble case, which is at page 165. We see on page 166 that Lord Clark, paragraphs E and F, is recognising the background to this case, and that the Court of Appeal allowed the appeal and granted the injunction in this case. We then see the recognition that Mrs. Gamble came onto the land after the injunction had been granted and became a defendant. And she was served with the injunction, and its effect was explained to her on the 21st of April 2005. And then again we see on page 168...
Which paragraph are you in?
My lord, that's page 166, that was paragraph G of the judgment. Starts partway through it. The defendant, Kathleen Gamble, was served with the injunction, and its effect was explained to her on the 21st of April 2005 after she had stationed caravans on plot 10.
That's not the judgment.
That's not the judgment, that's the argument.
Oh, apologies, my lord. No, sorry. It's the background to the case. Apologies. Yes. My lord, we then see the judgment starts on page 168, paragraph 2. Given the express terms of section 187b3 and the rules made under this section, it is not in dispute that in appropriate circumstances the section gives the court power to grant an injunction against a person who is unknown. These appeals arise out of injunctions granted against individuals whose identities were unknown when the injunctions were granted. There are two linked appeals. Each is an appeal from an order by which the appellant was held to be in breach of the injunction to be in contempt of court. So again, it's recognising the injunction is granted expressly under 187b3.
Your point essentially, Ms. Bolton, is that in the first of the two cases, the Morn appeal, if you look at the form of order granted in paragraph 15, it just said this order shall remain in force until further order. Nothing about trial. Get that at paragraph 15, letter G on page 172, whereas in the Gamble case it was until trial or further order. and you get that from page 174, just below the quotation, letter C to D. And your point is that in the Morm appeal, nobody suggested, certainly the court certainly did not say, that was an illegitimate form of order, and therefore the precondition of a trial, future trial, which the judge has erected, is wrong. That's the point, isn't it? That's why you're showing us this. We've looked at it several times before.
My Lord, indeed, my Lord, but it's also, yes, it's the point that this isn't simply interim relief either. The court's
yes,
clearly...
exactly, that's what I was just putting to you.
Indeed. But my Lord, there is one other part to Gamble that you perhaps haven't been taken to, which really very much clarifies that point in my submission, and that's on page 176. And it's paragraph 29. It's partway through the paragraph where Lord Justice Clark states, before expressing my conclusions on the particular points advanced by Mr. Paget, I should refer to the important decision of this court in Mid-Bedfordshire District Council and Brown, where the court comprised Lord Phillips. And he then goes on to say, so he's referenced it as an important decision. And we see in the quotations below it, and it's partway through what is paragraph E, the council applied for a final injunction prohibiting the change of use in breach of planning control. The judge granted a final prohibitory order but suspended it pending the determination of the planning application on the grounds that the interests of the safety and stability of the young children on the site overrode the objective of safeguarding the environment. This court allowed the council's appeal, and then they set out the correct approach. Now, in setting out that approach, they are, as you then see again on page 178, drawing on the decision in Mid-Bedfordshire and Brown. It's inescapable that the court, having recognised it was a final order, recognised that is the proper procedure, and Mid-Bedfordshire and Brown being a case that bound persons unknown, it seems inconceivable that...
Where do you get Mid-Bedfordshire and Brown binding persons unknown?
My Lord, if I take you to Mid-Bedfordshire and Brown, and that's in the...
Well, I think my Lord may have been referring to in this case. Is it 31?
My Lord...
In this case, Mr. Paget seeks to apply the principles in Mid-Bedfordshire and Brown.
My Lord, yes. My Lord, the principles in Mid-Bedfordshire and Brown are that the court is endorsing the approach of the Court of Appeal on page 177, paragraphs 25, they're quoting from it there, onwards. They are then saying those principles inform the correct approach.
But Mid-Bedfordshire wasn't a persons unknown case, was it?
My Lord, yes, it was.
Was it?
My Lord, it's in the authorities bundle B at it's page 2588.
2588.
Indeed.
It's tab 2. My Lords, it's page 2589.
Well, I didn't go as far as 258. No, I only go to 2584.
My Lord, it was an additional bundle because the case was missed off the original list.
An additional bundle or additional case?
It's a bundle of additional materials. The Open Spaces Act, Mid-Bedfordshire and Brown, and depending on statutory interpretation.
I got it. It's a little thing. I wanted a little thin file.
Yes. I don't think I have. Give me a second. Do you know when it was sent in?
My lord, it's in section E of the electronic copy of the bundle. That helps.
Section E. No, I don't think it is. Not in mine. I haven't got a section E. Do you know when it was sent to the court?
Amended. My lord, I believe it was Thursday morning.
About 11:25.
Been told about
Thursday
11:25 on Thursday morning.
Okay. That's last Thursday. Got it. Thank you very much. I called it Spencer Bauer because that was the first entry.
And my lord, Mr. Willers is very helpfully indicating as well that the committal on this injunction is also in the bundle at tab 41, and again that also confirms it's a person's unknown order. And you'll see in
So, what's the page for the committal?
well, my lord, that's at a different stage. But if I may just very quickly on this particular.
Yes, I mean, you're right that the order was granted against persons unknown. You can see that from page 2589. But it plays no further part in the court's decision. What the court is deciding is, was it right to suspend the order so that Mr. Brown and his family could have their rights taken into account, or not? The fact that the order as originally granted extended to a number of named defendants plus persons unknown doesn't really tell you anything, because the dispute that the court was deciding was between identified and indeed named persons, namely Mr. Brown and his extended family. So I really can't see what help you get from that.
My lord, the help I get from that is only this, that it was a final order against persons unknown, and it was expressly considered in Lord Clark's decision in Gamble.
Not for that point, for a different point.
My lord, no. I accept that. I simply draw to the court's attention that there is nowhere in the Court of Appeal's decision that there is any reference to that being a question mark over section 187B. Now, my lord, so then answering the final of those questions on Bromley, and is it inconsistent with Canada Goose? We say no, it's distinguishable, and if you go to Bromley.
I mean, being distinguishable is not necessarily inconsistent with it being inconsistent. Right, not very well.
My lord, it is if the reason it can be distinguished is because Bromley is dealing with public law rights and statutory rights, and Canada Goose is dealing with private law rights. And
okay, you said that, yeah. Where are we going now?
And my lord, in the Bromley case, which is at page 335 of Bundle A of the authorities, we see on page 347, on page 346, the permission, but the basis of which permission to appeal was given. And it's the relevant part is on 347. And we see it's to do that the reasons given on the second reason given, there were some 34 injunctions to date. And later down into that reason, further injunctive relief, if it continues to be sought and granted as it has been to date, would appear to carry a risk of supplanting the existing statutory scheme for the removal of gypsies and travellers supported by government guidance. In addition, the injunctions which had previously been granted pursuant to Section 187B of the Town and Country Planning Act 1990 arguably prescribed the lawful exercise of permitted development rights. All these matters appear to me to merit appellate consideration. My lords, that is materially what is different about Bromley. Bromley is considering the statutory rights and public law rights. It's not, in my submission, particularly surprising that there was no reference from the court to it in Canada Goose, because Canada Goose was dealing with a very different situation and very different rights. Indeed, I provided written submissions for the fourth intervener in Bromley, which of course included London Borough of Redbridge and the London Borough of Barking and Dagenham, who put their cases and their orders before the court as part of their submissions, which have again, of course, now been reconsidered again in these proceedings. And again, our submissions were again based on the statutory provisions for which we relied upon, not on any other basis.
Well, you're quite right that the injunctions sought in Bromley were sought under Section 187B. But correct me if I'm wrong, there is no discussion of Section 187B as distinct from private law claims in trespass, which are discussed in the judgment of Lord Justice Coulson. There is nothing which says, well, Section 187B stands apart from claims in trespass or nuisance or whatever it happens to be. Is there?
My lord, no, they're considered, and the cases of which rely on the statutes are considered.
What, the scope of the statute?
Well, no, my lord, the injunctions are considered, which are primarily injunctions under statutory provisions. Bear in mind in Bromley that the appellant in Bromley, before the High Court, amended their injunction to include trespass at a very late stage, following the intervention from the first to third interveners, that there may have been an issue under planning law with permitted development rights.
I mean, the appellant's notice in that case, which was by the local authority, said that the judge had been wrong to set too high a threshold for the harm caused by the threat of trespass.
My lord, it did, and indeed, but their case was also based on 187B and a proportionality test. And my lord, the interveners intervened on a planning point. The second intervener again had obtained their injunctions under planning acts, had intervened, and the fourth interveners did as well. The court were primarily faced with public law issues.
Well, but they don't say that. It's
Lord,
true that the background is a claim under 187B, but you need to show us, do you not, that that fact was in some way, if not decisive, then at least influential in the way that the court reached its decision. And I, speaking for myself, can't see that it was.
I mean, 19 says it wasn't. Having completed her review of the facts, the judge noted the legal basis of the claim was a claim for anticipated trespass.
well, my lord, that I make the point that it was only one of the basis of which Bromley had brought their claim. And I simply
But at the
make
very
the point.
least, it was relevant to what they were deciding in Canada Goose, because Canada Goose was dealing with the process, the procedure, and the procedure of bringing claims in these courts is under the CPR.
And my lord, it seems to me that the position is, as I've submitted, that these cases are distinguishable from Canada Goose, but
Sorry to interrupt. Did the judge at first instance refer to Section 187B in her judgment?
maybe I'm not sure.
Well, don't take up time now, but if you're able to answer that question at a later stage, that would be helpful.
My lady, I will find the answer to that question. As I say, I know that that was part of her reasoning on.
Yeah, you see that 347 just above paragraph 26. She refers to section 187B, saying that the injunctions arguably prescribe the lawful exercise of permitted development rights, but that seems to be as far as it goes in the discussion.
My lord.
In addition, the sentence starts, in addition, the injunctions which have previously been granted pursuant to section 187B arguably prescribe the lawful exercise of permitted development. That's why it merits appellate consideration. But, all these matters do.
My lord, yes.
I mean, I come back to the point that we have to be careful to attempt coherence and not salami slicing.
My lord, I entirely accept that, but it does seem that in relation to planning law, that there has been a statute which has been applied for some time and understood that it has been properly applied to both interim and final orders on the basis of the statutory provisions. Now, one of the points, my lord, that I need to cover on that is the practice direction and the suggestion that there cannot be compliance with the practice direction in relation to newcomers. My lord, you'll find the relevant provisions of the CPR were in Authorities Bundle B, page 73.
What's the number of the practice direction?
My lord, it's practice direction part 8, and you'll find it under. Apologies, I've not.
Yeah.
Practice direction 8A, and it's
Paragraph 20.
paragraph 20.1.
Yeah.
And you'll see that it relates to applications under section 187B
Yes.
or 214 of the Town and Country Planning Act. And well, you'll see that it's paragraph 20.4 that deals with the identification. We've looked at that in the case law, and I've explained how, on the evidence, that is capable of binding a newcomer, as it did in the Gamel case. And in the context of these cases, and I'll take the Lordships to an example in a moment, that can be achieved with reference to the forming of encampments on the land that is identified as part of the injunction, being the evidence and the description given. In relation to paragraph 20.5, the description of the defendant under paragraph 20.4 must be sufficiently clear to enable the defendants to be served with the proceedings. Of course, it then goes on to recognise the rights under Part 6 to either dispense with the service or to seek service by an alternative method. And my lords, in these cases, the courts have done both. Some judges have taken the view that they are satisfied that alternative service can be effected by posting on land and of the placing on the local authority's website and social media. Other judges have taken the view that they would prefer for an undertaking to be granted to do all of that, but to dispense with service. And in my submission, that's also an appropriate way to approach it, because on the question of is the case sufficiently exceptional to justify it, that can be justified, one, on the harm, alternatively, on the basis that otherwise would be to thwart the intention of the statute, which is to permit persons unknown orders to be granted. So there are mechanisms for serving persons unknown under this procedure, and the courts have readily and frequently made those alternative service orders. Indeed, in all of the cases of which I represent, alternative service orders were granted. In the Harlow case, the service was dispensed with on the condition that they posted on the land and on their social media. So in my submission, 20.5 does not produce a bar to an order binding a newcomer, and again, that's the approach taken in Gamel. My lords, turning to an example.
Ms. Belkin, how long are you going to be? I'm just looking at the timetable. I think the appellants are supposed to have finished nearly an hour ago. How are you doing?
My lord, I don't have much more on this. I then have to deal with my final order point. My lord, I do apologise. I would.
Well, it's up. I mean, which final point do you have to deal with?
My lord, it's my point for the issue 1 appeal, of which I need, which is the Vice President ordered a rolled-up hearing, which is that the court ought not to have disturbed 3 of the appellants I represent's orders in any event, because they were final orders. And my lord, again, I think a submission made by Mr. Giffin yesterday morning may have slightly misunderstood our position on that.
Okay. Well, can we get through it ASAP?
My lords, you'll have seen, so very briefly then, you will have seen in my skeleton argument I refer to the Carnwath report, and I refer to the Hansard extracts. We placed a significant amount of the Hansard extracts in to demonstrate that there was no discussion of limiting the injunction to a final order. I won't take your lordships to that, your lordship and
Well, how is that admissible, actually? Well, I mean, can I just flag up what we're concerned about whether the Hansard material is admissible?
Well, my lady, I think that those submissions were made yesterday by Mr. Bowes, and my lady, we've admitted that. We've also admitted Lord Carnwath's lecture, which explains how the provisions came to be, and obviously the report. The report, of course, being heavily relied upon by the House of Lords in Porter and reproduced in significantly in the Porter judgment.
Yeah.
My lords, finally, on the issue 2 point, the natural justice point, which Mr. Giffin dealt with yesterday. Of course, in all of these cases, it's appropriate, even at the final order stage, that there is a liberty to apply clause in the judgments, and we saw in Gamel that the Court of Appeal gave direction that it ought to be the approach that they apply when they become a party to vary the order, and indeed again that has always been the approach of the appellants in these cases, and is frequently should always be the approach on a 187B case, binding persons unknown, that is contained in the order. We see that in Redbridge case, and the final order in the Redbridge case, which is in the documents bundle, volume 1, at page 817, which was the final order of Mrs. Justice Farby. And this is going to feed in, my lords, to my, or my lady, to my second point, which is on the final orders. You'll see in the recitals that this was hearing the claim for final injunction and disposal of the claim. And you'll see paragraph 14 of the order on page 819, providing what's called the safety valve in persons unknown litigation. That anyone affected by the order can apply to vary or discharge the order on application. My lords, my lady, that brings me to my additional point in this appeal, which is the skeleton argument at tab 8 of bundle 4. Where on the issue of whether the court has power, either generally or under CPR 3.17 or otherwise, or specifically having regard to particular terms of the relevant order, to case manage the proceedings and or to vary or discharge injunctions that have previously been granted by final order. You see on page 96 there that we summarise in paragraph 17 Nicklin J's decision that the court has jurisdiction over final injunctions because their terms A expressly provide for a continuing jurisdiction of the court, and in any event B apply to newcomers who are not parties to the relevant proceedings when the relevant order was granted.
So which paragraph is that?
My lordy, now skeleton argument is paragraph 17, where we summarise the judge's decision at paragraph 120 of his judgment.
120.
My lord, yes. My lord, this issue only applies to the London Borough of Redbridge, London Borough of Barking and Dagenham, and Basingstoke and Dean, all of who had final orders when their cases were called in before Mr. Justice Nicklin. And to be very clear on our position on this issue, we do not dispute that a non-party may make an application under CPR 40.9 to vary or set aside an order. That's the case on any final order that affects a non-party, and that is a safeguard within the CPR. We also don't dispute that the same would apply to CPR 39.3. But both of those provisions require an application by a party, a non-party or a party affected by the order. And unless that application is made, the order is final. There's also an additional question that the court would have to consider in this case, and that is whether the liberty to apply provision in itself means that the court retains jurisdiction to case manage the case in any event. And we also say, no, that requires an application. And again, I will take you to the Court of Appeal's decision in O'Doherty on that issue.
But so what?
My lord, sorry.
I'm sorry, so where does that lead you?
My lord, so in our submission, where it leads us is the Court of Appeal's decision in Doherty is that liberty to apply clauses do not prevent an order being final. They are coloured by, their width is coloured by the principle of finality.
Well, so your point is, all those ways of applying to the court don't give the court an overall power to case manage itself, unless there's a specific provision in the order which provides for a review. Is that your point?
My lady, that is the point, and you'll see that the learned judge in this case, first of all, relies on 3.17 and the case of which we also relied on of Ralt and Northwest Strategic Health Authority.
Well, except the judge actually says the court has jurisdiction over these, quote, final injunctions because their terms expressly provide for the continuing jurisdiction of the court and apply to newcomers who weren't party to the proceedings when the relevant order was granted. What he's saying is this is a different species of final order from what a Doherty or any other case is talking about, because it's a jurisdiction which the court is exercising and requires to continue to exercise by the very nature of the order being against persons unknown.
My lord, indeed, but my lord, in our submission that's wrong, and it's wrong for the following reasons. It's wrong because the liberty to apply clause is only triggered by an application.
No, it's not liberty to apply, it's continuing jurisdiction.
My lord, indeed, the judge says that in relation to Ralt, but he only refers to part of the sentence in that judgment.
But some of the orders contained provision for review, didn't
My
they?
lord, indeed.
You're not saying that on a review the court couldn't change them in some way?
My lord, no, and I'd be very clear. I'm not suggesting for 1 minute that if an application is made in these final orders by a non-party, that the party will not be heard and would not be entitled to vary or discharge the order.
But the court has power to act of its own motion under the rules.
My lord, where there's a review...
Anyway, has a general power to act of its own motion.
My lord, my submission is not if the order is final. It requires it to be an application under the CPR, under 40.9 or 39.3, or an application under the liberty to apply clause on its terms. And my lord, we see that first of all in the Virgin Atlantic and Zodiac Seats case, where if we look at the... Well, my lords, first of all, I ought to say, bear in mind that the learned judge in this case believed he could reconsider these cases on the basis of a case called Speedier Logistics. That's how these cases were called in. Speedier Logistics was a case concerning an interim injunction pending trial to preserve assets. And what had happened is the basis for needing to preserve the assets in that case had fallen away, and the claimant hadn't restored the proceedings and sought to discharge the injunction. And the court said in a situation of that type, you were obliged to come back and do that. And on that basis, the learned judge took the view that because of Bromley and because of Canada Goose, local authorities were obliged to restore these cases. And that is how the cases were called in. Now that was wrong because, as the Court of Appeal have said in Doherty, changes in case law do not have retrospective effect. So, unfortunately, the judge was considering a High Court decision on an entirely different basis.
Was that an order by the judge, or was it an order by the President of the Queen's Bench Division, or what?
My understanding, my lord, was it was an order of the judge in consultation with the President of the Queen's Bench Division.
Where's that recorded?
My lord, I'm not sure we have it in the bundle.
I believe it was an order dated 12th of October of last year, which should have gone into the bundle and doesn't seem to have done so.
Can we see it, please?
Yes, I'm sure we can.
The judge describes it in part at paragraph 28 of his judgment. Defendants who made the order, but he says on the 16th of October, with the concurrence of the President and Mr. Justice Stewart, an order was made for a case management unit. Actions elsewhere were transferred.
Oh, the paragraph 28.
Yeah.
So all these were, I mean, you say they were a bunch of final orders which had been made at first instance by various different judges of the Queen's Bench Division.
Oh, yes.
There were then some new authorities, Cameron, Ineos, etc., right? And then the judge said, well, we've got to look at all these again.
My lord, indeed.
So what jurisdiction did they have to do that?
Well, my lord, that was a point we made in written submissions to the judge from the start.
And that was swept away in paragraph 120.
My lord, yes. And my lord, the position is, they were all of the in our cases, the three that we bring an appeal on issue 1 for. All of these were cases where there had been an alternative service order, an interim on notice hearing, a final hearing and disposal of the claim, and a reasoned judgment, and hearings which had taken, even though there hadn't been a defence the entire day, and the consideration of somewhere in the region of 5 to 8 lever arch files of evidence. There is judgments for each of these cases. Indeed, on the Redbridge one, behind the order is the reasoned judgment of Mrs. Justice Farby, with detailed consideration of the criteria to be applied. We say they're final orders unless and until somebody makes an application under the CPR under 40.9, or they rely upon the liberty to apply clause in the usual way. And when we look at I'll give your lordships the reference because I'm mindful of time.
So I'm sorry, just give me the reference in a minute, but I mean, what's being said here is that there's no application by a person unknown in any of these cases.
My lord, yes.
There's no application by the council, the authority, in any of these cases, but some judge or a group of judges saw a bunch of new cases and said, we can now ask the court to reconsider. I've never heard of that.
My lord, well, whilst we accept that the court could do it on the interim orders because they were there still to be case managed and considered.
Maybe, but
well,
these are not interim orders.
These are not interim orders, my lord, and that was our point.
Are there any interim orders that they called in?
My lord, the other 5 I represent are interim orders.
That's the Test Valley.
My lord, indeed. And again, we obviously, on Test Valley, of course, that's an interesting case to reference because, of course, Test Valley was a case where the court considered both Canada Goose and Bromley and had only 2 months earlier granted an order accepting 187B was separate from Canada Goose and Canada Goose didn't apply. And again, we did make an application to the judge to dismiss the orders bringing Test Valley within the claim.
So how did anybody know about these cases?
Well,
somebody was searching through the record.
My lord, I believe it was raised in the Enfield case that there were more of these.
What is the Enfield case?
My lord, that was Mr. Wolfe's case before Mr. Justice Nicklin, where they were seeking to extend the terms of the final order, and there was an issue over whether they could do so, and then they brought fresh proceedings.
Sorry, where is the Enfield case? What's it called? I've missed it.
It's page 2074 in Bundle B. Lord, I do have my copy now of the 16th of October audit has got some of my scribbles on it, so I can either find a clean one later in the day or show you this if the board wishes to see it.
Well, let's have a look at it.
And I'm told Ms. Kane is sending the Lordship's clerk clean copies.
Very good. So 2074 is a telephone hearing in front of Mr. Justice Nicklin on the 2nd of October 2020. And that was an application by the Borough of Enfield to amend their Part A claim and extend an injunction for 3 years. Right?
My lord, yes.
And did he do that?
My lord, no, he didn't. And you'll see it 2082. That I believe the position was that counsel in the case had been asked to research the position as to whether local authorities were to bring back before the court cases where there had been decisions such as Bromley and Canada Goose. And I believe that counsel was given very little time to do that. And that's where the case for speedier logistics comes from, on a very short adjournment, of which you'll see at paragraph 28.
Well, at paragraph 8, we see the judge saying that, as recognised by the claimant, the legal landscape that governs proceedings and injunctions against persons unknown has transformed since the interim and final orders were granted in this case. And there they are. Then what?
Well, then the judge goes on to consider whether he will amend the claim form and extend the injunction. Then following that, paragraph 26, my lord, you'll see the reference to following the decision in Canada Goose.
Sorry to interrupt you, Ms. Belton. Where do I find this document?
Oh, my lord, it's in Authorities Bundle BC.
Oh, authorities.
Authorities bundle B. We're now
And
at
it's at
2090.
2074, and we're on 2081.
Yeah.
My lord.
I mean, my concern, I'm afraid, is that this seems rather unorthodox to me. Where he says at 28 that that was a case dealing with a freezing injunction, the judge addressed the question of the duty of the claimant in circumstances where events occur after the date of the grant of the injunction which render information previously given to the court not relevant or accurate. This is very, very different here because this is if it is, it's a change in the law.
My lord, indeed.
And it's long been established that if the law changes after a decision has been reached on the old law and the question is final, that's it. Because there must be finality.
My lord, indeed.
So what's going on here? Was that argument raised?
My lord, that was the argument we raised in relation to issue, in concerning issue 1. The judge thought to we relied upon...
Well, I'm more interested in this judgment we're looking at now, when he apparently called everything in. How did he come to the conclusion he had power to do that?
Because he applied the speedier logistics case.
But that's a completely different case of a Moreover injunction where there was information that was wrong. I mean, that's a completely different thing. That's not 5 authorities of the Court of Appeal that changed the law.
Well, my lord, I accept that, and we made those written representations fairly swiftly on receiving an order that referred to the case as the reasoning for calling in the cases. We then further made those submissions at the hearing, and we referred to case law on the very point the Lordship has just identified, that the case changes in case law do not have retrospective effect. We relied upon the recent decision of the recent decision, sorry, the 2013 decision, the Serious Organised Crime Agency, no Doherty, from the Court of Appeal. And the judge sought to distinguish that on the basis that he said, well, that was inter partes litigation and this concerns non-parties. But with respect, that's not the point. The point is it's a change in case law that doesn't affect final orders.
Yeah.
Well, I find this a great concern. Could you just show me in this judgment you've just directed us to of Mr. Justice Nicklin in October last year, where he then deals with what the calling in aspect?
My lord, he doesn't. What he does is he then seeks, I think, the agreement of the President of the Queen's Bench Division, and we've received an order, and I think we will need those orders because those orders expressly refer to the Speedy Logistics case as the basis.
He does leave it hanging at the end of the judgment, doesn't he? He says,
I think you may be assisted. Mr. Wolfe has just.
paragraph 46.
So
He
the order.
adjourns the application.
My lord, Mr. Wolfe is behind me and is indicating if it would assist the court because he was obviously present. That he
Well,
would
of course,
explain what happened.
it may well assist the court. Can I just tell my colleagues here, because they may not have this order, but I've got the order on the screen now. It says, this order has been made with the concurrence of the President, Mr. Justice Stewart, the judge in charge of the civil list. And it's made by Mr. Justice Nicklin on the 16th of October in a number of cases, various claimants in Schedule 1, various defendants all gathered together, and it says, has a recital that upon the court in the Enfield case having adjourned the application for an interim and final injunction in respect of 96 sites and directed a hearing fixed for 2 days in January, and directed a case management hearing, and that directed the Attorney General be invited to instruct an advocate to the court, and upon it appearing that injunctions similar to that were granted in all these cases in Schedule 1, the most proportionate way of managing the resolution of any common issues is by identifying lead cases from them, and without a hearing and of the court's own motion, it is ordered under CPR 30.24, don't know what that is, Section 41 of the County Courts Act, that the actions in Schedule 1 are forthwith transferred to the High Court. Each claimant are to upload C-file copies. All claimants are to ensure the claim form is put in. Each claimant identified must file a completed questionnaire. And any claimant who, having considered the Court of Appeal decisions in Canada Goose and Bromley, may discontinue their claim or apply to discharge the injunction. And reasons, the recent hearing in the Enfield case has led to the identification of issues that are likely to arise in other cases involving local authority-wide injunctions to prohibit trespass. The issues concern existing injunctions that have previously been granted, in most cases for several years, as well as renewed injunctions. Principles have been subject to review in those 5 cases. Court has identified the cases. I mean, it's an extraordinary order. So there's going to be common issues, and wants to bring in all the traveller injunctions.
My lord,
Just tell me what you say about the jurisdictional recital that CPR 30.24 allows it to
I think
happen.
that's just transfer to the QV from elsewhere.
Yes, correct. Sorry. That's transfer.
Yeah.
So what's the jurisdiction to do this in relation to final cases?
my lord, we say there isn't because we say that the court is, and Mr. Nicklin relied upon his case management powers, but there's no case to manage. And that's been...
So if you're right, your issue 1 is this point, right? And that is properly before us,
My lord, yes.
nationally, then we can't hear any of these cases.
Well, my lord, you can hear the interim. I accept that whilst the order is extraordinary... That
We can
the
hear
High-
Tess Valley.
My lord, we would say that there is... whilst the order is extraordinary, I don't dispute that the High Court had jurisdiction to look at the interim injunctions because they were.
But that's just
continuing
Tess Valley 5.
My lord, in my case, that's 5 of my appellants. But in relation to the London Borough of Redbridge, London Borough of Barking and Dagenham and Basingstoke and Dean, they were final orders.
Well,
And
you say that. I mean, part of the issue in this case is what is a final order?
my lord, well, each one of those orders say on their face that they are in final disposal of the claim. Therefore, they can only be, and so that's when we then are looking at the case law of these issues, such as the case law in Virgin Atlantic Airways and Zodiac Seats, which was a patents dispute where the claimant had alleged infringement of their patent by the defendant. That was upheld in the Court of Appeal and a damages inquiry was ordered. Subsequently, the European Patents Office amended it, and so they sought to rely upon the fact that they were no longer infringing it. And the Court of Appeal, the Supreme Court made it clear that wasn't an issue of res judicata because it was a separate issue and it could be considered at the damages inquiry. And we see in that judgment, and that judgment is at Authorities Bundle B 1502, and in particular 1522, consideration of those principles by legal assumption. And it's paragraph 17, and it's the third consideration that he says, thirdly, there is a doctrine of merger which treats a cause of action as extinguished once judgment has been given on it.
I think I've got the wrong page number. This is the Virgin case. Do you have a tab number?
Apologies, I don't
56.
tab, so I'm grateful. Thank you.
Yes. And this is, and which paragraph was
It's
it?
paragraph 17, my lord.
Okay, thank you.
And it's partway down the paragraph in particular, in subpara E, where it starts third, there is a doctrine of merger which treats a cause of action as extinguished once judgment has been given on it, and the claimant's sole right as being a right on the judgment. Although this
I don't think my lord has got it. I don't know whether my lady
I
has.
have, thank you.
Apologies.
Give me the page again, please.
It's
It's 1522.
Yeah.
It's third, there is the doctrine of merger which treats the cause of action as extinguished once judgment has been given on it, and the claimant's sole right as being a right on the judgment. Although this produces the same effect as the second principle, it is in reality a substantive rule about the legal effect of the English judgment, which is to be regarded as of higher nature and therefore as superseding the underlying cause of action.
I mean, this is dealing with res judicata and final judgments. I mean, these judgments are all final in a manner of speaking, aren't they?
My lord, no, they're all final and subject to the same safeguards that any judgment is subject to, in the sense of 40.9 applies to any judgment.
I mean, that's debatable. I mean, the thing that I'm the thing that I'm most concerned about is that it doesn't seem to have been debated when they were called in. I mean, it's obviously for the reasons given in Virgin in Lord Sumption's very well-known judgment, so you don't need to read it all out. We're, pretty familiar with it. It's obvious that the court could not just call in a final judgment given after a trial between the parties, deciding legal issues on the grounds that some legal issues have been decided differently in subsequent cases.
Oh, yes.
That way would lie perdition, right? I think we can all agree on that. These are cases that are ongoing in some way. Some of them had provided for a review. All of them were against persons unknown who could involve newcomers, and therefore newcomers would need to have the right to apply to the court. All of which makes this rather more debatable, right? Makes the principle rather more debatable. Certainly as regards the newcomer. But what I don't see here is a proper. I'm feeling there was a sort of assumption, because the judge himself had made the order doing the calling in, that the assumption had been made that these were all up for grabs.
My lord, indeed.
That's what happened, isn't it, really?
My lord, indeed. And my lord, your lordship makes the point that they're continuing orders. And my lord, that's partly what the learned judge quotes from in Rolt, but he doesn't, what the Court of Appeal in Rolt make clear.
So I don't know what Volt is.
My lord, it's at page 1241 in the bundle, and the relevant paragraph is at 1247. The court's considering the jurisdiction under 3.17.
Could you just remind me, please, Miss Bolton, which paragraph of judgment part we quote?
So for Rolt, it's paragraph 146 of the judgment, my
Page?
lady. The page of the judgment, my lord, or the page
Page
of
of the
this.
bundle.
1247.
The judge refers to paragraph 15 of Lord Justice Hughes's judgment.
My lord, he does, and he stops. Well, it's referring to part of the paragraph 15, where there may possibly be examples of non-procedural but continuing orders which may call for revocation or variation as they continue. Now you find that at the bottom of page 1247, and you'll notice though that that's not the complete sentence, because the very next words are, an interlocutory injunction may be one of them. Maybe one, sorry, but it does not follow that one or the other of the two assertions mentioned, erroneous information and subsequent event, can be made, then any party can return to the trial judge and ask him to reopen the decision. In particular, it does not follow, I have no doubt, where the judge's order is a final one disposing of the case, whether in whole or in part. So, my lord, we say that the court simply didn't have jurisdiction to call in the final orders. Whether it was appropriate to call in the cases at all is I accept, as I say, that there are cases to manage, and that comes to the final case on the final order points we make, which is to do with the case of Terry, and the reference in that case from the Court of Appeal that there has to be a case to manage, and that there isn't a case to manage once an order is final. And the only way there would be a case to manage in these cases would be if an application was made under one of the CPR provisions. Or the
But aren't you on a
apply.
bit of a horns of a dilemma there? Because if there's no case left to manage, how does a newcomer become party to anything?
Well, they become party to the order, and the proper approach is then for them to apply to vary or discharge the order, and that's effectively the same as 40.9, but it's instead we draft it into the order. And Indeed, it is a conversation that you frequently have with the High Court when you're seeking 187B order. It's not unusual for a judge to raise when you're seeking a final order, why is there a liberty to apply clause? And it always should be there. But it is still a final order, and it will require a trigger either under the CPR or the liberty to apply clause for the court to have jurisdiction to case manage it once again. Otherwise, and we see that distinction in Rolt, that the learned judge makes, he states part of that sentence, variation of concerning continuing orders, but the Court of Appeal make it clear they're talking about interlocutory injunctions there. And I do accept that the court therefore has jurisdiction on the interlocutory injunctions, but they don't on the final orders.
But even if this kind of order, which might provide for review or liberty of apply or whatever, is a hybrid, your point, I think, is that unless there's a trigger under the CPR or under the terms of the order itself, the court doesn't have an overarching supervisory role to play.
No, my lady, certainly one of the reasons given is 3.17. That certainly isn't the case,
Yeah.
and there isn't any other case management power that could be relied upon because there's no case to manage. Finally, of course.
Well, there might be a case to manage, but only under the terms of the order itself, not in some broader sense.
Indeed. And, of course, if we're right about Canada Goose, then that's an additional reason for which the court had no right to for these orders, because even if you could find a way to do so, if the basis for it is changing the law and that law doesn't apply, then again, these cases ought not to have then been called in.
Well, I mean, that sort of begs the question, because Canada Goose may decide lots of things or it may not, and until we've decided what it decides, we can't decide what it decides.
But it's simply an additional reason.
The question here is whether it's fortuitous that issue 1 is described as issue 1, because very much it is issue 1. If there's no jurisdiction in the court to have this case, then we shouldn't be having it, nor should the judge.
My lord, indeed, and I make this submission. I don't wish to cut across the submissions of my colleagues on this. I appreciate that they are arguing a different point, and I also accept that where an order is made under against the world under the case law development, such as an extension of the Venables or the Bloomsbury case, then I accept.
But that's not what happened here.
Well, my lord, exactly. I accept, though, that where those arguments are being submitted, that may be different and jurisdiction may be retained. So I'm not cutting across what others have said on this point. Our position is different, and our position has always been different, that these were orders under statutes, they're final orders. We're not seeking them on any other basis, and therefore that the court ought not to have disturbed them. My lords, unless I can be of any further assistance, my lady, those are my submissions.
So having thrown a hand grenade into the middle of this case and pulled the pin out, Miss Bolton, you're now proposing to sit down, is that right?
Well, my lord, I'm mindful of time, and so I've
Yes,
tried to take these points swiftly, because I apologise for running over, but that I had to make all the running on this point, and my earlier points were to some degree relevant to it.
Well, we'll hear, I'm sure, some very helpful submissions from the advocate to the court on this point.
Oh, lady, I'm grateful.
Who goes next?
My lord.
Mr. Jones.
My lord, Kimblin for
No, sir.
HS2. Can I make it clear that...
You are for HS2.
HS2.
You're going next. Oh,
Seems-
right, okay.
Seems sensible for the advocate to have the opportunity to explain why I'm wrong. And can I make clear at the outset that my intervention is on the basis of those parts of the case for which there is jurisdiction, as opposed to any that there might not. The thrust of the intervention and the skeleton argument is drafted very much on the basis that the judge's approach to these types of cases has a result, has an outcome, which is unworkable. It has a result which makes it practically impossible to obtain relief other than for a very short period of time in these sorts of cases by way of interim injunction. That's the thrust of the intervention. And in that regard, I want to make just 2 points, 2 submissions. And the first is very much to adopt what has been said by both Mr. Giffen and Mr. Anderson in respect of Canada Goose. I just want to say just a very small amount in respect of that, having regard to the very helpful document produced so very quickly by Mr. Giffen and his junior, Mr. Stokes. They provide paragraph 11 of their document submitted this morning. Some submissions in respect of Canada Goose, which are numbered 1 to 3, and essentially 1 is distinguish, 2 is conflict and inconsistency. And I have no quarrel with either of those, but what is said at 2 is...
1 is not much use to you, though, is it? Because in the case of HS2, they're almost all protesters.
My Lord, you've very much seen where I'm going with the point. 1 is really does raise the question, when one has cases such as destruction of development infrastructure projects, they are simple in some cases, trespass, but the origin of them is in respect of protest projects.
Yeah. You've got a combination of people occupying land which either you own or which you possess.
Yes.
For the purpose of protesting against the construction of HS2.
Yes. And one of the reasons that I raised the point is to go to the question of coherency, cogency, consistency in the law, and whether or not points 1 and 2 here, in fact, run together to some degree. Because it may be that the points made at 1 in some way explain why the approach taken in Canada Goose was as it was. Because Canada Goose was a particularly notable case for the way in which the injunction was approached. Very quite different in character. And evidently the Court of Appeal was very much focused on the particular facts and the circumstances of that case. And that will have informed the way in which it's approached the question of final injunctions. And so it may well be that those points of distinction, which are set out at 11.1, inform us as to why we have the inconsistency as between Canada Goose and some of the earlier cases. The primary submission which I adopt is that Canada Goose is inconsistent with INEOS for all the reasons which have already been submitted. The second point is more practical in nature and seeks to deal with solutions to the overarching set of problems which these cases seek to address. And the submission is this, that interim injunctions may be, but do not have to be for short periods. So one of the effects of the judgment of Mr. Justice Nicklin was to emphasise and take perhaps to a different level the need to get to trial very, very promptly. And the submission is that that may not, in an appropriate case, be the practical and necessary approach. Not least because in some cases, the difference between what is happening in the case at interim stage and what is sought to be achieved at trial is really not very different. And I seek to illustrate that by reference to only one document. It's the only document I'll take the court to. That's in bundle of documents number 2, where at tab 44, the court will find the judgment of the deputy judge David Holland's Queen's Counsel.
So I didn't get the page.
It's tab 44, 478 is where that starts. 478.
Yeah.
Where one can see from the heading that this is a case in which the two claimants seek injunctions against persons unknown, and then specifying what they're doing, in respect of land in the London Borough of Hillingdon, and it's known as Harbour Road. So it's a persons unknown injunction, and it's largely focused on trespass. And the reason that I'm taking the court to this is to illustrate some of the impacts of Canada Goose in practical terms, and to illustrate what can be, in fact, achieved properly and justly by an interim injunction which extends over a long period of time. And these injunctions, I've been told the court, have extended over a long period.
Well, you're pushing at an open door, actually, Mr. Kimblin, in suggesting that some interim injunctions go for very long periods of time. There is no mechanism by the court for review of interim injunctions which the parties allow to continue.
Yes.
And the normal provision, and remember I was head of the Chancery Division for some time, in Chancery injunctions is until trial or further order. Often that is made at the inter partes hearing, and there is in 90% or 99% of Chancery actions no trial. And unless the injunction is discharged when the case is settled, that can go on for years, and there is no mechanism for the court to review that process. Now, that's not only confined to the Chancery Division, it's done exactly the same way in Court 36 or 37 or whatever it is in the Queen's Bench Division. And so the idea that every case has to be brought on in some way to trial, or that the parties have a duty to do that, or that the court has a duty to review if they don't, is wrong, in my view. And I think that's what you're saying.
It is what I'm saying.
Yeah. Right, now let's look at Mr. Holland's judgment.
And it's at 128, which is at 525. It's the paragraph I want to go to, and it's in a section which has a subheading just on the previous page, the temporal limit of any injunction. And counsel in the case was asking for a period of 2 years for this injunction to continue. And at 128, the judge sets out 5 points which he takes into account in weighing up what has been submitted to him, and explains why you can see the reluctance to come to trial, and referring there to cost, referring there to 3, to where one gets to at trial, given the number of defendants and their attitude to the project. It's likely that many of them would wish to participate fully, which they're perfectly entitled to do. Then drawing attention at 4 to what is likely to be at issue. At 4, very likely to be a trial on the merits of a scheme. And then at 5, really referring to the resource involved. And this was a case in which the judge in the previous pages in this judgment rehearses the submissions of 13 people who appeared in person and 1 who was represented. And it's really drawing attention to the question, is it really going to be very different if I have a trial? And that's the practical point.
Well, that depends on the facts, doesn't it? I mean,
It depends entirely on the facts.
in the case of HS2, presumably once you've built the line, people will stop protesting.
Indeed. But the submission is to draw attention to the spectrum of cases and simply to say that in an appropriate case, a long interim injunction might be appropriate. And part of the assessment of that might be for the judge to weigh up what it is that one is going to receive in terms of a different set of arguments upon a final hearing. And that can
However,
cut both ways.
I mean, however, if there were power, and I'm not saying there is, for the court of its own motion to call in an interim order, and then determine whether it should continue, it would presumably determine whether it should continue if it had that first jurisdictional step. If that first jurisdictional step was possible, it would have to consider the continuation according to the current law.
And which in this case had a particular impact by reason of Canada Goose. And it was...
Well, maybe, depending on what we decide, yes.
My apologies, but in the case to which I'm referring before the...
It did for him,
judge.
yes.
And so the approach taken was very much informed by Canada Goose.
Yeah.
And to the extent that the deputy judge in this case did in fact grant permission to appeal against part of his order, which required that the matter be set down for trial. The judge was plainly concerned as to the merits of whether or not it was a good idea.
And I see that Mr. Justice Linden, in the case of Hackney, only granted an injunction on the basis that there would be a trial in the near future.
Yes.
I mean, that's a very novel concept.
And that is the point on which we really focus this submission, that that's not a practical approach, nor is it, in our submission, consistent with the earlier decisions in respect of this jurisdiction. And so that is the purpose of taking the court to HS2's experience in this regard, and it really plays out in this further way, which is to draw attention to the impact of Mr. Justice Nicklin's judgment in respect of what he calls a traveller case. Traveller cases is perhaps a useful handle, but we submit that those sorts of classifications, whether they be classifying by reference to protester cases, whether it's a classification by any sort of activity or group of people, in fact, rather confuses things and doesn't bring about coherence, because practitioners tend to focus upon the handle which seems to best apply to them, which would submit is at least unhelpful.
Well, you say it's chaos.
Confusing, lacks coherency.
Would you say the same about classification by reference to causes of action?
No. Because plainly one is dealing there, particularly by reference to the legal tests which have to be passed in order to make out the cause of action. So a case may very clearly point out that it's addressing some issue in respect of trespass, but it's unhelpful to have a case which apparently is of application to traveller cases. That is unhelpful.
Because a traveller case encompasses a whole multitude of different possible causes of action.
Indeed.
Yes, well, anything else?
Unless I can assist in any other
Well,
way.
it's very helpful, if I may say so, Mr. Kenman. I'm very pleased we allowed you your 10 minutes. It's been a little bit longer. Who's next?
My Lord, I'm going to start with the Canada Goose line of cases, the big issue that's before the court. Of course, I need to address the issue which Ms. Bolton has addressed you on separately, but I'm going to leave that, if I may, until the end of my
You say
submission.
she's utterly wrong, I think. Do you?
I do say that, and I'll obviously have to deal with that in some detail.
I mean, is there just to make me happy before lunch, Mr. Jones, is there, in a nutshell, the reason why she's so wrong?
Yes. The nutshell reason is that one has to approach the question of the court's ongoing powers by reference to the kind of order that is under discussion. And here, the orders which we are talking about are extremely unusual. They're extremely unusual because they are made without notice, engaging or possibly engaging Article 8 rights, and they're ongoing. And, of course, there's a separate question about whether all of that means that they can't be made at all, and that's the issue I'm going to kick off with. But if they can be made on that basis, then they are extremely unusual, and there are questions of fairness as well as Article 8 questions, which have to feed into any decision to make the order and to continue it. That's the first important part of the context of these orders. But the second important part of the context is my Lord Justice Lewison's point, essentially, which is that the mechanism which the appellants rely on as making the orders acceptable in the first place is said to be a mechanism whereby a person who breaches the order in the future then becomes a party to the proceedings. And so, by their nature, these orders, if they can be made, are forward-looking, and the proceedings, by their nature, carry on even after the orders have been made.
Well, I completely get all that. And, you know, subject to anything anybody else says, it seems obvious good sense. But it doesn't answer the question Ms. Bolton made, which is that it's not for the court to make the application, to review them. It is for the newcomer or the claimant or somebody in the proceedings.
No, my Lord, it answers that for this reason, which is that the power of the court is expressed in CPR Rule 3.3.1, which I'll take you to in due course, but which essentially says any power exercisable can be exercised on an application or by the court. And that's what I say is the procedural power for the court to take in and look at these final injunctions. Now, in an ordinary case, of course, the court wouldn't.
Well, there are two slightly different questions, aren't there? One is, can the court do it? And the other is, should the court?
Precisely. So 3.3.1 is, can the court do it? The answer is yes. Should the court do it? Well, ordinarily, the answer would obviously be no, because in inter partes litigation, all the principles of finality would point towards that being a completely unacceptable exercise of the court's jurisdiction, and it wouldn't ever be done. But as I've said, we are here in a very different world. We're not talking about normal orders, we're talking about very unusual orders.
Yes,
So
I mean, my problem with that, and I get all that too, is I quite understand that we're in a very different world, but we appear to be in a world where the call-in took place because of 5 Court of Appeal decisions which changed the law. And that is precisely the reason why finality is the reason not to overbear finality. So that's what I really need your explanation for. I mean, I completely understand if the court thought it had been misled in the cases like Spedia, if the court thought that the whole thing had been granted on a false premise of fact and had reason to believe that that was the case, fine. But when the law changes, we don't go looking through the annals of the court record to find cases that might have caused injustice and ferret them out, do we? I've never heard of it.
Well, my Lord, of course, ordinarily no. But if these orders can be made, the court is essentially putting itself in the position of managing orders which have a much wider reach than would be made in inter partes litigation. That's what's cautioned against at the end of Canada Goose. So that's the last few paragraphs of Canada Goose, where the Court of Appeal makes the point that essentially one shouldn't make these orders because, to put it in a nutshell, these are matters for democratic forums, not for the court, and inter partes litigation is an adversarial system, and if it isn't used as an adversarial system, then it breaks down. And my lord, if, notwithstanding all of that, the court does make these orders which do go into that territory, then in my submission, the court's powers then to look back at them and to see whether these ongoing interferences can be maintained is appropriate. My lord, there's another just a procedural point which I should mention, which is, as I understand it...
Sorry, Mr. Jones, you said ongoing interferences. Well, interferences with what?
Well, with, among other things, Article 8 rights.
Well, potentially.
Well, potentially.
But that, the engagement of convention rights, whether Article 8 or anything else, doesn't of itself mean the court has an extended jurisdiction.
Well, my lord, I'm addressing the question of whether the court should exercise the power, which
So
I said has
in
under
answer to the question,
3.3.
can the court? You say yes,
Yes,
CPR 3.31.
yes,
That's the end of that.
yes.
The court can. In answer to the question, should the court, or perhaps more properly, was the judge entitled to,
Yes.
you say that Article 8 comes into it.
Well, it comes into it, along with the points which I've made about the fact that these are injunctions which are made without notice, without the participation of the parties. They are unfair for that reason. Now, obviously, the first argument which I need to address is, are they so unfair that they fall within the kind of order that can't be made at all? We're assuming here that I'm wrong
that's
about
an
that.
extraordinary presumption, if I may say so. I would have thought that ordinary people would think it remarkable that we were being told that it is unfair to prevent people trespassing on public land to the detriment of hundreds of ordinary citizens. I mean, you can't just assume that Article 8 rights go one way. They go many ways. And, I mean, it's not that... I'm balking at this, Mr. Jones, because this is not the function of the advocate of the court. To presume that Article 8 rights change our procedure. This is a procedural question and has to be answered in a procedural way. Of course, Article 8 rights are an issue on both sides.
My lord,
Maybe.
certainly apologise if I'm straying from the role of the advocate, my lord. It wasn't my intention to do that. Article 8 rights may be engaged
Yes, they
on
may.
both sides. They may be engaged on both sides.
But they're not. These injunctions are not automatically to be said to be unfair.
Well, when I, my lord, say that they're unfair, I am using the expression in the way that it's used, I say, by Lord Sumption, when I come to Cameron, which is to say that final orders which are made without notice, without participation of the people who are subject to the final orders are unfair. That's what I say Lord Sumption says in Cameron. Now, I accept that there's a question then, which is that does that apply to, for example, trespass orders, which is one of Mr. Giffin's points, where one can't trespass, and that's, in a sense, if one trespasses, there's no getting away from that.
Well, in a plain vanilla squatter case, you enforce a possession order against whoever happens to be on the land
Yes.
at the time when you enforce it. And incidentally, Lord Sumption is wrong in saying that Order 113 was introduced to get injunctions. It wasn't. It was designed to get possession orders.
Yes, yes. The way the unfairness would come in a trespass case is in this way, which is that if one asks the question, when there is an application for an injunction to prevent trespass, and the court has to decide whether to issue the injunction, and of course it might not issue the injunction on Article 8 grounds. My Lord, you yesterday asked Mr. Giffin, well, is that, in that context, is the court there deciding that there is no trespass, or is it simply deciding that there is trespass, but for Article 8 reasons, it wouldn't be proportionate to issue the injunction? And Mr. Giffen said the latter. And I agree with that. But that's important because the same principle then applies if one thinks about a newcomer case where you're seeking a precautionary injunction to prevent trespass. Because one can ask the same question there. Why would the court possibly say no, trespass is wrong? One might say there's nothing unfair about making it just on the basis that trespass is wrong. But the answer again is that if people did have notice, then they would have potentially things to say about it, including in particular on the basis of Article 8, because of course that's what comes into play in this context. And so one has a situation where, in my submission, and I accept that this, I have to join the dots between this and Cameron, I'll come to that, my lord, but in my submission, the reasoning in Cameron does apply to these injunctions, and it is ultimately a reasoning which is founded on fairness. And it flows through to Ms. Bolton's points, because, as I say, it forms part of the context when one asks the question, should the court maintain an ongoing jurisdiction or oversight, if one wants to call it that, over these cases. I say that there are good reasons and specific reasons to a newcomer injunction why the court should do that.
My eyebrows are raised, Mr. James.
Well, my lord,
So please take time, if you want to, later when you've dealt with the cases, to come back to this point.
I will, my lord. I'm very grateful for that. Could I also just flag one point, which is there is, I think, a slight distinction in the procedure here, which is that there was, of course, the order calling in the cases, and reasons were given for that. And my lord, you've seen that that was, as I understand it, on the basis of change in the law. Now, that order isn't as such appealed by Ms. Bolton. What's appealed then is the later decision in the judgment where things had moved on somewhat, and there's a whole section in the judgment. It's not just paragraph 120, that's the summary, but there's, I'll take you through this, but there's a very lengthy section, paragraphs 127 to 148, where the judge considers these issues. And the question he's asking himself at that stage is, do I have the power to interfere with these final injunctions? And the reasoning is, I accept it's a bit different to why he called them in the first place, but in one sense that is water under the bridge, because he then addresses the actual issue before him, and that's, those, as I understand it, are the conclusions Ms. Bolton appeals. So I'll take, my lord, I have to go through that in some detail, but I should mention that as well in that context. My lord, if I may, then I'll go to what is called Issue 1 on the letter from Council, the joint list of issues where we'd set it out. My lord, I don't know whether you have that before you. It didn't make its way into a paginated slot in the bundle, I don't think. I'll read it out.
What are you looking at?
There was a letter, a joint letter, sent by Mr. Giffen, but it was from all of Council identifying the issues that we say arise for determination on these appeals.
Right.
An issue number 1 is expressed in this way: whether the judge erred in holding, as a generally applicable proposition of law, that save in claims for against the world injunctions, a final injunction will only bind persons who were parties to the proceedings by the date of the final order. And I read that out because it's important to underline that question, as framed there, obviously accepts that final injunctions, including precautionary injunctions, combined parties, that's self-evidently true, but it's also accepted by the judge, by everyone here, that unknown persons can be made parties to an action, so they could be bound if they're identifiable. That's what Cameron is about. So the issue before you is not whether one can obtain a final injunction or a precautionary final injunction against persons unknown in general. Of course one could, and that might include, for example, listing out identifying owners of land if one doesn't know who they are. They'd be identifiable by that description, or people currently residing on land. The issue is, of course, whether it is possible to obtain a final injunction, precautionary injunction, but binding on newcomers. And as to how one might do that, just in terms of the drafting, there are two principal mechanisms. One is to define the people who are caught by the injunction by reference to some conduct that they might engage in future. And of course that's GAML. GAML is a type of example of that. The description in GAML of the people who were caught is actually identical to the description of the conduct which is prohibited. So automatically doing the conduct makes you a defendant in GAML. Now the other approach, the other way of drafting an injunction to catch newcomers is to do what Mr. Anderson's clients did in the Wolverhampton case, which is you simply express the injunction as applying to everyone. So it's an injunction against the world. And I outline those two different mechanisms because Mr. Anderson submitted to you, and I entirely agree, that they amount to the same thing. So an injunction against newcomers expressed in the GAML style is the same thing as an injunction against the world because it applies to all of us in the event we do the conduct which is prohibited, just like any other against the world injunction would do. Now, once one starts from that proposition, the simple answer to issue 1, which I read out, is that one cannot obtain a final injunction against newcomers, which is to say an injunction against the world, unless you bring yourself within one of the recognised categories of case.
Closed categories.
Yes, closed categories of case. I mean, I'll show you, my lord, that the categories have been expanded incrementally. So not entirely closed, but certainly recognised categories of case where that is permitted. And the authorities on against the world injunctions recognise two types of case where such an injunction may be made. One is certain interim injunctions. The other category is certain exceptional final injunctions, and of particular relevance to this case, where the court is compelled to make a final injunction against the world by the Human Rights Act. And that is why I started my skeleton. I'm going to start today, when I come to the authorities, not with the Cameron line of cases, but with what I've called the against the world cases, because in fact, what the appellants want is against the world injunctions. And you will see, my lords, my lady, that if one were to say in a blanket way, well, we have identified a new kind of against the world injunction, which is one final injunction, which is one which applies to anyone who in future might breach it, that my submission just pulls the rug out from under the against the world line of authorities.
So, I mean, the truth is that until 2019, none of this was recognised, and judges up and down the country were granting against the world injunctions in persons unknown traveller cases everywhere, and there are thousands of them having been granted. I've granted many myself. And that was all based on total ignorance of the law.
My Lord, I have sought to find the cases which have looked at the two streams of cases, the contraband of cases and what I've called the persons unknown cases. And one comes to that in the later Court of Appeal authorities, of course, when we come to Canada Goose, but the different streams of authority are brought together there. But they're not brought together that I've seen in the earlier cases. So that question of how the two streams go together.
The fact is, you say that it was all, I mean, the law is, when the Supreme Court decides Cameron, it simply declares what the law is, and all the cases that are inconsistent with it on your analysis of Cameron shows that all those injunctions granted over the last 20 years and more, actually, because it started in the 60s, were wrong. They should not have been granted, and there was no mechanism for preventing travellers camping on other people's land, basically.
Well, my Lord, yes, but subject to this point, I mean, I entirely accept, yes, that the law, when it's stated by the Supreme Court in Cameron, is expressed in the law as it's always been.
Yes, so everybody was wrong. I mean, every judge in the land drafted these injunctions.
Well, I'll have to. My submission is that when one gets to Cameron, Lord Sumption does say that the law essentially has been misapplied, and that's the basis on which he then
you
goes
accept
on.
the court can because of section 37.
I accept.
So this is a question of should.
Yes, I accept that. So, but that's the against the world authority.
I mean, it's absolutely fantastic ramifications, your submission. It has really serious ramifications for the use of land and people's rights to quiet enjoyment of other land.
Yeah,
and yet you say this is, we're absolutely bound by Cameron to go down this route.
Well, my Lord, yes. Certainly I've seen my function as putting, to some extent, the way the judge went through these authorities. And that is essentially, my Lord, where one comes. But there's the against the world line of authorities. But then, of course, there's the Cameron line of authorities. And there needs, of course, to be consistency between those. Now, what Cameron's actually about is the circumstances in which one can make an unknown person a party to the proceeding.
And order damages against somebody who's completely unknown and never going to be known.
Precisely.
Quite extraordinary difference.
Now, it's a conceptually different question, whether one can be made a party versus making the orders against the world. But the two lines of cases do, of course, need to be consistent. And in my submission, they are consistent in light of Cameron, because it holds in this is what I say the reasoning, the binding reasoning of Cameron is, that you cannot make an unknown person a party unless they're identifiable so that they can participate fairly in the action before final relief is given. And I'll go through it in some details, but I do say that it applies to injunctions as well as damages. And my Lord, I do...
So that applies also to 187B?
Yes. And just as I have said that permitting final injunctions against newcomers would cut across the against the world case law, so too in my submission it would cut across Cameron. If I'm right that Cameron applies to injunctions, then an applicant can't come to court and say, well, I understand what Lord Sumption says about not being a party, but I've essentially got a workaround, which is that I don't want to make unidentifiable people parties. What I want to do is have an injunction that only binds parties, but anyone who breaches it in future will become a party. Because in my submission, that would achieve by the back door what Lord Sumption, in my submission, has said can't be achieved by the front door. My Lord, I see the time. Is now a convenient moment to pause?
Yes. So how long are you expecting to be, Mr. Jones?
Well, my lord, I had agreed with my learned friend who's speaking after me that I could eat in slightly to his time, which would have given me a total of 3 hours. We are, I see, slightly behind schedule, so I will, over lunch, if I may, see if I can cut that down a bit.
Well, I'm not encouraging you to cut it down. I think your submissions are of significance. And if the parties think we need to take more time for this case, like tomorrow afternoon, we will consider doing so if asked. I would rather hear these submissions fully and properly so as to have the best argument available than not. Right. Thank you.